And we're just going to hit the record button now. Great. Okay, I'm showing 10:01 on the clock, so it is time to get going. Again, my name is Syer Farmer. I'm a business advisor with Women's Enterprise Center, and I'd like to welcome you all this morning to our mediation forum. We're going to talk this morning about mediation, what mediation is, how it is the same or different from legal process like using a lawyer. I know our attendees number continues to climb. Welcome to all of you. I can see we're up to 12 and 13. So welcome to all of you that are joining. Just a reminder that this session is recorded, just so that you know that, and we will be sending it out after the session, assuming that everything is working on the recording side. It is a technical thing sometimes. Again, my name is Syer Farmer. I'm a business advisor with Women's Enterprise Center. You're joining here this morning to talk about mediation. It's really great to have you all. On the line, I also have Ashley, who is our mediator, but I'm just going to talk first a little bit about Women's Enterprise, just a very small amount. You've probably seen most of Women's Enterprise Center on our webpage, and we do have people joining, so I'm just going very slowly here as people join in. Welcome to everybody. Yeah, that's great. So there's a picture of me for any of you who want to see who I look like. I'm the business advisor in the Kelowna office. Women's Enterprise Center has 3 offices. Our head office is here in Kelowna, where I am right now. And our other office, of course, Vancouver and the Seabus terminal. And we have a small office as well in Victoria. And I am a business advisor, which means I help women with their business issues. I help support women through all kinds of business issues. And the business advising service is free of charge for any people looking for support with their business. And of course, I'm also a loan assessor, so I do look at a lot of business loans. We're here today to talk about mediation. So let's see, how many people do we have now? Yeah, we're up to 16. So again, just a little slow start as we move forward. Again, that's me. You're hearing my voice, Syer Farmer. And I'm talking just a little bit about Women's Enterprise Center and who we are, our offices, our 3 offices in BC. Our business loans up to $150,000, our professional advice and resources, skills training, which is what you're doing here today, is building your skill base. We also have a mentoring program, and of course, our supportive community. And if you're online, you're looking at a picture of Sarah Claire. Sarah Claire is also in Kelowna. You see her beautiful dog there. He's a gentle giant, and she's one of the businesses that we support here in the Okanagan. We're up to 16 attendees. That's excellent. All right. So good. Now, just a reminder for any of you that joined late, this session is recorded. Okay, you can also ask questions. The questions will come in through the chat box. So please ask questions as we go along, and we'll be happy to do our best to answer those questions for you. And hopefully you've pulled up your chat box, or you can put questions up on the Q&A. You should see at the top of your screen a little Q&A button. Again, you can ask questions through the Q&A or through the chat as we go along. So let's go ahead and get started. Joining me on the line today, we've got Ashley, and those of you that are on your computer, you'll see a picture of Ashley. Ashley is a lawyer, a mediator in the Lower Mainland. Ashley, now, before we get started, one of the things I forgot to do was ask you how to pronounce your last name. So
right. It's Syer.
Syer, excellent.
Syer, yeah. It's for a last name that only has 4 letters in it. It causes people an awful lot of trouble.
Yeah, you see, my name is fairly easy to pronounce. So I often don't get asked how to pronounce my name. But welcome, Ashley. It's so great to have you. Ashley's a lawyer and a mediator, which is very interesting. And it's the great thing about having her fulfill both roles, as she could talk about what a mediator is and what a mediator does versus what a lawyer would do and what a lawyer does. And Ashley then has both skill sets. So it's really, really great to have you join us here today, Ashley.
Yeah, thanks. I'm thrilled to be here. And also I happen to be a woman entrepreneur. So it sort of rounds it all out for you.
That's right. And in fact, you are, because Ashley has her own law firm. And so you are a woman entrepreneur on top of all of that. So it's really great. And Ashley was mentioning to me that she just got back from doing some more mediation training at Harvard. So you're continuing to build onto your skill set.
Yeah, yeah, and I'm always super excited to talk about mediation, but especially now.
Hmm.
Mhm.
One of the things I'll add is I actually myself did a training in mediation at the Justice Institute in Vancouver, so I am a certified mediator as well. And the great thing about mediation and building your mediation skills is even if you don't go on to be a professional mediator, mediation really helps open up the way we see the world and helps us reframe relationships because, you know, in mediation, we're really looking for that common ground. But before we dig into that, well, let's go ahead and get started and just talk about. And Ashley, I'll put this over to you. Talk about, you know, how would you define what in your mind? You know, when people say to you, "What do you do?" and you say, "I'm a mediator," how do you describe that to people?
Yeah, it's and I whenever I'm having this conversation in writing with somebody, I have to clarify, not meditation, mediation. They're
Good.
different.
Yeah.
Yes, although both require some level of zen, I suppose. Yeah, so mediation is a the best way to describe what a mediator is a mediator is a facilitator. Our job is to facilitate a conversation. So depending on what the context is, we might be facilitating a negotiation where there's a dispute between people. We might be facilitating a conversation between people who are in conflict of some sort. We might be facilitating a conversation between 10 stakeholders who all have views on something that needs to get done in a more public kind of forum. Mediation takes a lot of different forms, but what the purpose of it really is solution oriented, and a focus on resolution and consensus.
Interesting. So one of the things you mentioned in there, you talked about mediation and you talked about negotiation.
Mm-hmm.
How are those the same or different?
Yeah, so in negotiation, it's the parties who are the stakeholders who are discussing with each other, negotiating with each other, whatever it is that they're trying to negotiate. The mediator's role is as a facilitator. So we're not taking a position. We're not, agreeing or disagreeing or making any decisions for anybody. But what we're doing is helping the parties or the stakeholders have a conversation with each other where sometimes they can't hear each other because they're so entrenched in their own needs and wants and positions that they can't sometimes hear that what's being said to them is actually something that aligns with what they want, because all they're hearing is what their own position is and something that sounds like conflict coming from the other side.
Okay, so what you're saying there is you're really a neutral third party. You're an additional person in the room that doesn't take sides.
Yeah.
You're there to help the conversation.
Yeah, exactly. And actually, in some parts of the world, the word for mediator is neutral. The word neutral is what they use instead of the word mediator. We are a neutral. That's the whole
Right.
purpose of being a mediator, is you are the neutral voice in the room.
Right. And that's very interesting because when you put your lawyer hat on, I would think that would be quite different. So tell us then, if a mediator is that neutral third party, they're in the room with the people that are in a dispute of some sort, and you're neutral. How would that be different if you were a lawyer in the room? What because people, the women that I work with and the businesses that I work with, they're often going to lawyers and they're getting the assistance of a lawyer.
Yeah.
What is the role of a lawyer and how does that look compared to a mediator?
So generally, when you go to a lawyer, you're going to a lawyer so that they can be your advocate. And so when you're in a negotiation and you have a lawyer sitting next to you, generally the reason that they are there is to be your advocate. They're there to advocate for your position and to give you advice about what it is that is a likely outcome or what looks like a good deal or a bad deal, and those sorts of things. So, a lawyer's role generally is advocate, an advice giver, whereas a mediator is neutral. You can't give, even though I am a lawyer and a mediator, I can't give legal advice to parties in a mediation. If they need legal advice, they need to go and seek a lawyer. But lawyers tend, just because of the nature of the profession, it tends to be a more adversarial prospect when if a client comes to me as a lawyer versus somebody coming to me as a mediator, they're coming to me as an advocate, not as a neutral.
Right. So if they're coming to you as a lawyer, or if you're wearing your lawyer hat, you are taking a side in the dispute because you're really there to advocate,
Mm-hmm.
and put forward the interests of your own client.
That's right.
Right. And so you're not, it's not about seeking, a balance in the relationship or about resolving the dispute necessarily. It's about getting the most you can for your client. And I'm not trying to put words in your mouth. So if I'm getting that wrong, please let me know.
Yeah, that's often the way it is. I mean, a lot of lawyers, myself included, are resolution focused. So, the goal will be to try to resolve whatever the dispute is, but that usually looks more like, well, I'm going to put forward an offer and we'll see what offer they get back, or I'm going to make a suggestion for how we resolve this and then see what their suggestion is back. Whereas the mediator is there to help the conversation along. And especially where you're dealing with some sort of dispute that involves people with an ongoing relationship, where that relationship needs to, or where the parties want that relationship to continue, having a mediator in there can actually help resolve a lot of the things that underlie the conflict, rather than just hammering out some kind of deal.
Mm. I'd like to dig into that a little bit more, but just before we do, I want to remind people that they're welcome to ask questions as we go along. And so for anybody new, there's two ways to ask questions. You can ask questions through the chat feature, or you can ask questions through the Q&A feature on your screen. And please feel free to ask questions as we go along. So if you're hearing something that Ashley's saying that you'd like more information on, or you'd like to dig a little bit deeper on that, please by all means post your questions and we'll do our best to get to those. So Ashley, you were talking about sort of the ongoing relationship and how important it is in mediation, especially if you're working with people who are required to have an ongoing mediation. Maybe they work together, or maybe they're family members.
Mm-hmm.
You're exploring some of the underlying issues. So I guess the question there, and what I'm curious about, is we've talked about how mediation is different from a lawyer. How is mediation different than therapy?
Sometimes as a mediator or even as a lawyer, I feel as though I am a therapist. So it's different. It's different than therapy in that it is. I mean, you're not there to resolve all the conflicts between parties. I mean, you're in terms of what that relationship looks like. Sometimes it's a happy benefit of mediation that you can sort of get to the bottom of what has caused the conflict. But it is solution oriented. And so, if the solution that you need is how do these people continue to work together, or how does this family business continue to function as a business, those are sort of the solutions that mediation would be looking at. Whereas therapy would be looking more towards, what's the root of this emotional issue that we can get to the bottom of, and whose mother loved who more as a child. That's not the sort of thing we'd be tapping into when we get into mediation.
So in a mediation, you're really going to focus on the issues at hand, what currently needs to be resolved. So you're not a counselor, so you're not going to get into the therapy side or some of the historical conflicts so much. You're really going to focus on what's happening now, on what potential outcomes might look like, keeping in mind that you want to keep the relationship strong.
Yes, and that's sort of a yes, but. Or I should say yes and, the rule of improv. Yes and. Sometimes in order to figure out where you are and where you need to go, you do need to look at what happened in the past. But we sort of use this analogy of when you're driving a car, you have the windshield and the rear view mirror. And if you had a rear view mirror the size of your windshield, well, you'd never get anywhere because you couldn't see where you're going. You need to see where you've been, but you need to focus on where you're going.
I really like that.
Yeah, it's a helpful analogy, I think. And, because sometimes, particularly where you're dealing with a conflict that's arisen in a small business, a partnership dispute or a family business, or where you've got coworkers who are in conflict, quite often you do need to figure out if there's something that happened that needs to be addressed in order to move forward. Sometimes what it is an apology is needed that was never given, and that's something that it's one of the things that I love about mediation is we can come up with really creative solutions in mediation that a court could never give you. And, if you're, let's say you're in a conflict between two partners in a business, and something happened along the way where one partner did something that the other felt slighted by. And now they've got into this conflict about something else, but there was never an apology given for the other part of it. I mean, you could go to court, you could get sorted out whatever you need to get sorted out, but a court's never going to order a party to apologize to another one. But that's something that can end up being a wonderful part of mediation, is an understanding of where the other party or other parties are coming from. And with that understanding, figure out, okay, how can I address this? How can we have this conversation to allow us to move forward?
I like that, the idea of coming to that understanding and then addressing, where the hurt has come from and where did the divide come from. Mm-hmm. So when you can address that, you can move forward. Now, you've mentioned a few cases already that mediation is well suited for. Maybe we can get into that a little bit more. That might be helpful for our listeners to get a sense of, what types of situations mediation is best suited for.
Yeah, mediation, I think, is there are times when it's more appropriate than others. And we're talking about this in in the context of businesses and particularly small businesses. I mean, there are lots of applications, family law, things like that. But within this context, I think that mediation is appropriate anytime there's a conflict that looks like it might be headed to court. It can be a way to avoid court. It can be appropriate where you have a breakdown in a workplace and you've got conflict between either a manager and an employee, or between different employees, or between shareholders or partners in a business. It's particularly appropriate, I think, when preserving the relationship between the parties is important. And so that can be within your own business, but it can also be, if your business deals, say you have a supplier that is an important supplier to your business, and you want to continue working with them, but at some point they've sent you something that really doesn't meet what you need, and you're in a conflict because they're saying, pay me for it. You're saying, well, you didn't give me what I asked for. But that relationship is really important to maintain. That's a situation where it might be really useful to approach mediation instead of just saying, well, I'll see you in court. Because as soon as you start that adversarial process, it can be a challenge to get that relationship back. So anytime when the relationship is important, I'd say. And then on the other side of that, sometimes things need to go to court. Sometimes that just happens. The parties are so far apart that they are, so entrenched that they just can't see past the end of their own nose. And, those situations, you can end up in the litigation process. And then once you start looking at, oh boy, we're about to go to court and we're going to be in trial for 10 days. When you're sort of on the eve of that, that's another time when mediation might be appropriate.
So, you can combine them? You're saying you can actually combine the court process with the mediation process?
Yeah, it's there are some situations where going into mediation before there's ever a court process started can make sense, and that I would say is more the case where you have this continuing relationship situation. Sometimes it's too soon to try to mediate before you've shaken out all the facts of a dispute. Sometimes there's just missing information. And if you can't get that information, sometimes you need to start a court process in order to get the information. Then once you have all the information, then you can look at, okay, how else can we resolve this other than going to trial or going to court? And so there are different stages in a dispute where you can look at mediation and ask, is this appropriate for mediation at this stage?
So you could very well then have started a court process or a legal process, and then as part of that, or as a side to that, maybe even have a mediator help you through a certain aspect of it.
Absolutely. You can, and the other thing too is sometimes, I'll get parties to a dispute and they'll say, okay, well, there's this one portion of it that we're never going to agree on. We're never going to reach a middle ground because for this, it's an all or nothing proposition. Because, one of us is entirely right or the other one is entirely right. Or it's something that can't be equally divided. But there are a bunch of other issues that they might be able to reach a resolution on. So you can mediate a portion of a dispute as well.
And that's really interesting to me because, of course, parties that go to court, the parties often believe that, their position is the right position, or that, so they feel that, they're proceeding through a legal process because they have the right solution or that they've been wronged somehow.
Yes.
And I'm thinking that people are feeling when they go to mediation, they're worried they're going to have to give something up.
Yeah, there's a joke in our little mediation world that says a good resolution is one where the parties walk away equally unhappy. Because in order to reach a resolution, one of the things I like to say to parties when I'm mediating is that nobody wins mediation, but also nobody loses mediation. Mediation is about finding a solution or a resolution that all parties can live with. It doesn't mean that you have to be thrilled about it, but it means that you have to live with it. And if you can't reach a resolution that you can live with at mediation, nobody's going to force an answer on you. Nobody's going to force you to accept something you don't want to accept. But if you go to court, that's exactly what will happen, is you'll have a solution imposed on you, and maybe you'll be thrilled with it, and maybe you'll completely lose. But that's in the hands of a judge. In a mediation, the parties are in control of their own resolution.
So the parties in the mediation are both sides, or all sides, are going to agree to the outcome or agree to the solution.
Mm-hmm.
Not necessarily, as you said, that it may not, be what their opening position is. It may not be maybe a little different than what it was when they walked in the room, but in the end, they'll agree that it's the best solution, and they'll. Mm-hmm. Right. Okay. So this is interesting because we talked about how a mediator is different than a lawyer, and we talked about how a mediator, is different than a counselor, and we're talking about mediation, and then, the legal process where a judge makes the final decision. What about arbitration? How does that fit into this?
Yeah. So arbitration's maybe best described as being sort of a hybrid between mediation and court, although it can just look a lot more like court. So in an arbitration, some of them will have a resolution process built into it, but generally if you go to arbitration, you're presenting your case and the other party or parties are presenting their cases, and then an arbitrator is making a decision. based on what they have before them. So it's a different process from a court process, but it generally has the same sort of result where you've got one decision maker who's imposing a decision on all of the parties. So you don't have that same ability to craft your own solution at an arbitration. There is this interesting mythical beast that's called Med-Arb, and it's a combination of mediation and arbitration. And mediators differ in whether they think it's a good thing or not a good thing. But the way that process works is you start off in a mediation, and if you can't reach a resolution that the parties as between themselves, then the mediator will take off their mediator hat, put on their arbitrator hat, and make a decision.
Oh, I see. So a mediator then, if they can't get the parties to come to a mutually agreed upon solution, can then dictate what the solution will be.
Yeah, and it's not something that I do. I don't. Mediators, as I said, will differ on whether they think that's a good thing or not a good thing. For me, I think it's hard to remain neutral if you think at the end of it you might be making a decision.
Yes.
So I generally don't take that approach, but I know sometimes the parties like that or want that. They want to walk out of the room with a decision. But from my perspective, it's the crafting of your own solution that really can make all the difference to the parties about how that solution gets implemented, especially if you're talking about a relationship building, or a consensus building. Parties are much more likely to stick with the solution that they hope to craft.
Right. That makes total sense. Of course, if you're involved in making the decision, you're more likely to follow through on whatever you've agreed to.
Exactly. Yeah.
I think one of the things that maybe holds people back from choosing mediation is that they don't really understand how the process works. Like most of us in society, we understand how the legal system works, more or less. We know that you hire a lawyer and you talk to your lawyer about all the situation, and then you get a court date and you go to court, and then the judge makes a decision. I mean, we kind of all see that. We've seen it on TV many times.
Except it usually takes 3 or 4 years instead of 20 minutes in a legal drama. But yes.
Yes, exactly. It can take a very long time. It can be very expensive as well.
Yes. Yeah.
And remind me if we don't get to it, let's talk about the costs around mediation. But before we get there, could you describe for our listeners, if they reached out to a mediator, what does that process look like and how long can it take, and just that whole flow, the continuum, so get a sense of that.
Yeah, so it's one of the things that I love about mediation is you can tailor it to fit the needs of the parties, and you can tailor it to fit the needs of the particular dispute. In a typical commercial mediation, I'd get a call from the parties or the party's lawyer saying, hey, we want to mediate. When are you available? We pick a date. They each give me a 5-page summary of where they're coming from. And then we sit down for a day and we mediate. And sometimes it takes 3 hours, and sometimes it takes 8 hours. And sometimes you don't finish in one day and you go to a second day. But it's a much faster process usually. So that's in sort of your typical mediation, where you're talking about something where there's not necessarily a legal dispute, or where there haven't been any court documents filed, but where you're talking about preserving a relationship or a dispute between shareholders. Sometimes the mediation happens in several parts. Sometimes it will, I always have a call with the parties individually ahead of time, just to get the lay of the land from them, where each other is coming from, whether there's any information that they think is really important for me to know, particularly where, if you're talking about a workplace dispute and there's maybe been an allegation of bullying, and one party says, I don't want to be in the room with them, to sort of get the lay of the land that way. But overall, it's going to happen somewhat quickly, certainly more quickly than court. But sometimes you'll need to break it down into smaller chunks. So sometimes you'll have, 2 hours on one day, and then a week later you'll do another 2 hours. Or sometimes you'll get halfway through a mediation and realize, hey, we actually need some information that we don't have in order to come up with a resolution. And until we have that information, there's actually nothing we can do right now to solve this. So the parties will go away, collect the information, exchange the information, and come back, and we'll jump back into the mediation. I have one that's very much like that right now, where several months ago we sat down in a mediation, figured out what all the issues were that we needed to be working on, and then realized, okay, well, we actually need to get a report from somebody to go and inspect this thing to tell us what's really wrong with it. And until we know that, we can't come up with a solution about how we're going to fix it. We need to know what's wrong first. So now that that report has been given, next week we're going to get back into mediation. Say, okay, well, now we have the information. So what can we do about this?
So let's go review that then.
Mm-hmm.
So it starts with somebody reaching out to you. It could be one of the parties, or it could be a lawyer on behalf of one of the parties.
Mm-hmm.
And they submit to you in writing a summary, both parties do, of what they feel is happening and why it's happening and what's important to them.
Yep.
And you then follow up with both the parties. I guess I'm saying both the parties, but do you do more than 2-party disputes?
Oh, absolutely. Yeah.
Yeah. So it could be 3 parties, 4 parties,
12 parties, 18 parties, you bet.
Yeah. Okay. So that's a lot of writing. If each one gives you a 5-page report, there's a lot.
Yeah, and I'm using that as an example. Sometimes particularly where I'm dealing with cases where there are no lawyers involved, I'll just say, give me a 1-page summary, or just give me a little written description that I can give to the other side, and I'm going to give you theirs, so that you can each see where the other one is coming from when they step into the room.
Oh, interesting. Okay, so you're going to share that description with the other side.
Yeah.
Okay.
Yeah, because the idea with mediation is that you want everybody who's involved in it to be forthcoming with information. So one of the things that I didn't mention that is really important about mediation is it's a confidential process, which is a wonderful thing, because it means that any information that's shared by the parties in the mediation can't be used outside of the mediation. So if you can't resolve whatever the dispute is that you're there to resolve, nothing that's said in the mediation can then be taken, and in court say, well, you said this, or you gave me that person's name. Well, I want to follow up about that. None of that can happen. It's a confidential process. So you want the parties to get in there and be forthcoming with the information that the other party might need to see what a resolution looks like.
So there's no risk to the party, no legal risk to the parties in undertaking mediation first.
Exactly. Yeah.
Okay, so let's go back to that. So the clients have reached out to you. You've got a written summary from the parties, which is shared with all the parties, and then you have a call meeting with all the parties just to make sure you're clear on what's important to them and what their perspective is before you actually sit down in the room together.
Yeah, it's largely just to check in. So if the parties have a lawyer, I'll just call their lawyer and say anything I need to know. If they don't, I'll just touch base with the parties and say, we'll go over what mediation looks like, but let me explain the process to you a bit. Is there anything that you want me to know? Just to kind of make that introduction and start building the relationship. In mediation, as the mediator, the relationship is really important. The parties need to trust you because you're there to try to help them. But sometimes they're coming into a dispute with a lot of mistrust towards the other side.
Yes, I get, the parties for sure would need to trust you. They want to be very certain that you're not taking sides.
Mm-hmm, absolutely.
So then you sit down, you're going to meet with them, and that's perfect what you just said, because I'm visualizing that meeting when the parties are coming together, and sometimes these people are in deep disputes and significant conflict. You talked about bullying as an example of something you might deal with. So what does that look like? How does that feel? And how do you get through all that emotion?
Yeah, so it's what I said before about one of the great things about mediation is you can craft how the mediation goes to suit the parties and the situation. There are times when a mediation can happen and the parties will never be in the same room together. And then there are other times where you do the entire thing with the parties in the room together the whole time.
Can you give us an example of that, Ashley?
Sure.
When you would choose to bring the parties together and when you would keep them apart?
Yeah, my usual practice is to start off the mediation with everybody together in the room. Um, then I'll explain to them the process, and that way they're starting off, everybody hearing the same thing from me, from their neutral, and knowing that they're hearing the same thing, knowing that nobody's getting different information. They're all starting off on the exact same page. And then I will usually give the parties an opportunity to speak to each other about what it is that they're there wanting to resolve. Now, sometimes that conversation ends up being really fruitful, and then you can continue the discussion. And a great mediation is one where I'm not intervening very much, where the parties are just finally having a conversation with each other, where they haven't been able to do that before. And sometimes, I'll give you an example. I do quite a bit of employment mediation. So an example that I can give you is an employee who had been dismissed, and it was a very unfortunate set of circumstances around it, around the dismissal. And the employee was very hurt and very angry still, and felt as though they had been not treated fairly by the employer. But they'd never had an opportunity to say that to the employer. And I knew that it was very important to them to be heard. And so as part of the pre-mediation call that I had with the employer, I said, I would like to give this employee an opportunity to, say to you in person how this whole situation has made them feel. Do you think that you can, sit and listen and hear what they have to say without reacting, and just allow them to be heard? And if they had said, no, absolutely not, I'm not going to listen to that, I wouldn't have let that happen in the same room. But this employer said, yeah, we understand that this was a very unfortunate situation, and yes, we will hear that. We want to hear that. And so I gave the opportunity to the employee to say how this whole thing had affected them. And it ended up, there were tears, and I could tell that it was very difficult for the employer to not react. But that helped us start talking about resolution, because the employee felt as though they had been heard at that point. So, that's an example of, and then after that had happened, I did put them in different rooms so that we could have conversations about what resolution looks like without them having to put those things on the table in front of the other party. Now, if the employer had been unwilling to hear the employee, or if the employee was so angry and said, if I see that person's face, I'm, going to break down and not be able to speak, then I probably would have started them in different rooms. I would have encouraged them to come together at some point, but I wouldn't have forced it. I hope that answers your question.
Yeah. So you're gauging in advance, the level of emotion, and I think it sounds like you're also gauging somewhat their ability to deal with their emotion and stay collected through the process.
Yeah, absolutely.
And then I'm sure with the kind of mediation you're doing, you run into those situations where, like you said, people do break down, and there is emotion, and people are crying, or probably some anger that needs to be worked through. I'm really getting a sense from you. Is those deep conversations. It sounds like you're facilitating those deep conversations that seem to be so hard for us to have.
Yeah.
Not with family members, but with people we work with as well.
Absolutely. And I see it a lot in workplace disputes. I also see it, another example was three three shareholders or founders, I suppose, of a company. One was a scientist, one was a business guy, and one was the bank, I suppose, put it that way. And they had come together to create this company, and then things went sideways. And they had all put their heart and soul into this company. And then when things went wrong as between them, there was still a lot of emotion. What they were really talking about was, ownership of a product and who gets what money. So on the face of it, it just looks like money, but there was a lot more to it that just needed to be addressed. And those things, I will say, are generally never going to get addressed in a courtroom.
Right, because in a courtroom, the judge may order a payment and decide who gets owed a certain amount of money, but all the issues behind it and the emotion around it never gets resolved.
Yeah, that's right. And so you can end up, winning, and I say that with air quotes around it, you can end up winning a legal case and still walk out of the room feeling as though nothing's been resolved.
Right.
And you can walk out of a mediation feeling that way as well. But, hopefully the things, a good mediator, their job is to get to the issues that need to be resolved. And sometimes the issues have to do with the relationships.
So what exactly is a good mediator then? How would I know if I was choosing a mediator who I should choose?
That's a great question and a really hard one to answer. Because some mediators will be perfect for certain types of disputes and a poor choice for other types.
Are you saying that mediators specialize? Is that what you're saying?
Some do, yeah. But also, so not all mediators are lawyers. That's something to keep in mind. Some great mediators are actually counselors, or they're business people, or they're, I met a lovely mediator who's very good, who's actually he's a member of a religious organization. So your mediators can be different. They can come from different places, and sometimes where the mediation really is going to be just dealing or mostly dealing with an emotional component and fixing a relationship between family members in a family business, you may want to consider whether you want a lawyer mediator or whether you want a mediator with a background in counseling or psychology, or there are these different types of mediators. So that's one thing to consider.
Can you give us a little bit of guidelines, or guidelines is probably the wrong word, but can you guide us a little bit on why would I choose a lawyer mediator over a counselor mediator, over just a mediator who's not affiliated with any other, just to have a mediation practice?
Yeah, it's a bit of a hard question to answer. I think if the main crux of the issue that you're trying to resolve, or the issues you're trying to resolve, are legal issues, you're probably going to want a lawyer mediator.
So maybe I can have an example of that. Would that be, let's say, a shareholder agreement? A shareholder agreement is a legal document, so maybe in that case, a lawyer might be suited. But in a bullying situation, that feels like that might be a little different than a legal process?
Potentially, yeah. It's just, choosing your mediator is so much about fit. It's about whether or not you're comfortable with the person. And so, I wouldn't say that you'd never want a lawyer mediator in a workplace bullying situation. In fact, probably often you would want that. There are a lot of, but if it's a very specific workplace dispute that you're needing to mediate, you probably want to make sure that your mediator has some experience in workplace disputes or in employment law, or is a workplace investigator, or things along those lines. So, just doing your homework rather than picking a name off a list. So Mediate BC has a roster of qualified mediators that meet the Mediate BC qualifications. So if you're looking for a mediator, that's a really excellent place to start.
Yeah, because if you want to find a lawyer, they're pretty easy to find. There's legal offices everywhere.
Sure.
Drive down
Yeah,
the street, there's a legal office. But if I wanted to find a mediator, is that where I would start with Mediate?
I I would suggest starting with Mediate BC. Yeah. It's they've made sure that everyone on their rosters, and they have different rosters. They have a civil mediation roster, a child protection mediation roster, family law, and a Med Arb roster. And uh, each member who's listed on those rosters have met the criteria necessary, including the training, the experience, and the continuing education that Mediate BC requires. So if you're not sure where to look and you think, gee, I don't know if this person, what sort of training they've had, you know that if you go to Mediate BC, everyone who's listed there has the criteria that Mediate BC requires, and you can find out more about that on their website. And it'll also show you some of the practice areas of those mediators and what they specialize in, and as well where they're geographically located.
Yeah, that's important too, because you'll probably want to find a mediator in your community. I suppose you do some phone mediation, would you?
Yeah, some mediators do telephone mediation, others don't. I do. I've done several of them. Um, they can be um, they can be great where you've got parties who are far away geographically from each other. Um, it it's a little bit harder um, when you don't have everybody in the room, but for certain disputes, it just makes sense. Um, the most recent one I did was a purely business related dispute. So the issue really was about money, not as much about repairing the relationship. But the parties just weren't able to reach a resolution on their own. And we were able to do it over the phone in about 3 hours.
Oh, nice. Nice.
Yeah,
One of the things we didn't talk about is the cost of mediation.
yeah.
Can you give us a sense of what that cost might be?
Yeah, so again, it's one of those answers that goes, it depends. But when you think about, let's use a legal dispute, for example. So if a legal dispute arises in the context of your business, and you go to a lawyer and you hire a lawyer and you draft a claim, you file it in the court, you have all the steps that go along with it, maybe you have a day or two in court. Um, and it drags on for months or years, that can be a very expensive proposition where you've got, lawyers' fees anywhere from, 200 to 400 to $500 an hour. And you think about the number of hours that's going into all of that. I mean, you can quickly and easily be into the tens of thousands of dollars. Now, mediation, on the other hand, mediators' fees vary quite widely, but a lawyer mediator, so a mediator who's also trained as a lawyer, their fees will probably be about what they would be if they were acting as a lawyer. But it's usually split between the parties. And quite often a mediation is done in a day or in 2 days. And so rather than looking at, months and months and potentially tens of thousands of dollars, you could be looking at, 8 hours worth of mediator work split between two parties or three parties. That takes place over the course of a couple of days. So potentially there's a lot of cost savings because it is often a faster process.
Mhm. So because there's less time for the professional involved, the fees can be lower.
Yeah,
I'm assuming that there must be some fee for some of that background work that the mediator does up front.
yeah,
Yeah.
yeah, yeah. And so that'll, you'd have an agreement with the mediator similar to a retainer agreement that you might have with a lawyer, where the mediator sets out, these are what my fees are. This is how it's going to be divided unless you agree otherwise, as between yourselves. And these are the things that I will charge you for. And so those things that a mediator will charge for are usually these pre-mediation conferences or telephone calls with the parties, reviewing any briefs that they give you, and then the actual time spent in the mediation.
And what about a court-ordered mediator? Who pays for that? And
So court-ordered mediation isn't really something that happens in BC. There used to be a small claims mediation program that unfortunately has been done away with. So you can still ask for a mediator under the small claims court rules, but you have to pay for it yourself. I'm not aware of any court order mediation processes in BC right now.
so once you get into that legal route, you're probably going to go through with the legal route then. The court's not going to divert you to a mediator necessarily.
Well, a court might suggest that you go to a mediator. Sometimes at a pretrial conference or something along those lines, a judge might say, have you considered mediation? You may want to give some thought to that. But then it would be up to the parties to go and decide to do that. Now, if you are in a court process, if you're within the small claims court, there is something called a settlement conference that takes place over the course of an hour, and it's before a judge. And the judge will just sort of get in there and see any chance we can resolve this. And if it looks like maybe, then they'll try to resolve it with you as in sort of a mediator role. And if it doesn't look like there's a chance of it, then they will just set down court dates. If you're in a Supreme Court process, you can, if you really want to go to mediation, but the other party doesn't necessarily want to go, or they don't want to talk about it with you, you can serve on them a thing called a notice to mediate, which says, effectively, I want to go to mediation and you have to come. And then they have to come. So you can do that. That's an option that's available to you. In my opinion, it's better to have some agreement between the parties that they want to go to mediation. Because if you force someone into it, they could sort of dig in their heels and say, I don't want to be here. I don't want to talk about it. So it's better if you can get the buy-in. But there's not a situation, there are some jurisdictions, particularly US ones, where a judge will order people to mediation. But that's not something that really happens here.
We're not doing that in BC so much, I see.
Mm-hmm.
So you gave some great examples of the situations where mediation is being used. You talked about bullying and workplace conflicts, partnership breakdowns, or disputes around partnership agreements, dismissals. This isn't a business-related one, but of course we see mediation being used a lot in divorce.
Oh, yeah.
Are there other prime examples that you hear a lot of where mediation is being used a lot?
Anytime that there's a court process underway. So, I mean, in terms of specific examples, those are the bulk of them in a business context. But really, anytime a claim has been filed and a court process is underway, there's an opportunity there. So, I mean, it's not really responsive to your question, but really, anytime there's a dispute is where you can see that. I mean, I see it a lot in insurance claims. That's a huge area for mediation as well.
Insurance, yeah.
Yeah, and that can be personal injury. If you think about you've been in a car accident, that sort of thing. But it can also be where you've got maybe you had a flood in your home, and or in your business, or you have some kind of business insurance coverage, and now all of a sudden you need to make a claim, and that's not being, your insurance company is denying your claim. Those are other areas where mediation can be great. So,
I think that's actually a really good answer, Ashley, because what it tells us as listeners is mediation is really all encompassing. It's really, because I'll talk to people and say, well, I'm not going to go to mediation because it's, my this conflict is bigger than that, or it's more difficult than that, or it's, parties are more entrenched than that. But really, what I'm hearing you say is, if you have parties in conflict, they're disagreeing about something, if there's an opportunity to bring them together, to talk it through, to work it out, to come to some solution, then whatever the issue is, broad ranging, whatever that issue or issues are, can be brought forward through a mediation process.
Absolutely. And, mediation is used in all sorts of incredibly complex disputes. It gets used in billion-dollar construction disputes. Mediation gets used in coming up with peace accords for the UN. I mean, these are wildly complicated issues, and they're things that mediation is great for.
Those are big issues indeed.
They are. And at a certain size of dispute, like the UN example, the mediator really is acting as more of a facilitator. If you think about a facilitator who's sort of chairing a board meeting or some kind of public forum, that can be the role of a mediator in that, which looks slightly different, but it's the same set of skills. You're still working towards consensus building. Yes. And I would say that some of the complex matters are even more well suited for mediation.
Yes, and given what you've said, because the courts struggle to deal with the complexity, there can only be one solution, and it often favors only one of the parties.
Yeah.
So let's review what we've covered this morning. We've talked about, what mediation is and how it is the same or different from a mediator is the same or different from a lawyer, and how they would be the same or different from an arbitrator and or a counselor. Really,
Yeah.
What you're saying is that a mediator has pieces of all of those skills. And they're a neutral third party. They're there to help the parties come together to facilitate conversations, often very deep conversations, to resolve whatever the issues are and resolve some of the emotion around those issues, so that when the parties leave at the end of the day, they can maintain their relationship and they can rebuild. They don't have to walk away and be adversaries for the rest of their lives. There's an opportunity for them to rebuild the relationship, which would be especially important in a family situation or in a workplace situation where you have to continue to work with that person.
Yes. Yeah.
We talked some more about how to find a mediator, and that was a great tip, Ashley. That Mediate BC site has a list of mediators who meet the qualifications and their geographic area. So if people are looking for a mediator in their community, they can find one. We touched on the cost of mediation and how it can be a less expensive process and certainly a much quicker process than a legal process. And then it brings us to 9:59. Holy smokes, where did that hour go?
Yeah.
So last word to you, Ashley.
Oh, sure. I love mediation. I love being a mediator. And the reason that I do is because it gives me the opportunity to help people and parties who aren't hearing each other hear each other and find the common ground and actually reach a resolution instead of continuing a conflict. It's, if you think of lawyers as warriors, mediators are peacekeepers. And that's how I'd really encourage people to think of mediation as mediators as peacekeepers. That's what we're trying to do. We're trying to help you resolve the problem instead of continue it. And I love talking about mediation, as you can tell. So if anybody has follow-up questions or they want to ask how mediation can be helpful, I'd love to answer those questions. I'd love to talk about that anytime.
And how would they reach out to you, Ashley?
Yeah, they can. Anybody can reach me. My website is syerlaw.ca. That's my last name, SYERLAW.ca. All my contact information is there. It's a little bit of information about mediation as well. So people are welcome to email me or call me, anytime. Would love to be able to help mediate some issues for any of our forum folks.
Thank you, Ashley. That's very kind of you. And to anybody out there who wants to reach out to Ashley, you know where to reach her. Thank you all to everyone else on the line today and for joining us today. I hope the session was informative for you, and I hope you have the steps that you need if you want to follow up with mediation process. Enjoy the rest of your day. And we'll hopefully see you again on the screen for another forum. Thanks, everybody.
Thanks.